enough we delay. Confirmed open now.
Okay, good morning members, and we have a quorum and I call the meeting now to order. Welcome all of the members here this morning to this second meeting of the Committee for Communities. Can I remind everyone in the public gallery that mobile phones must be turned off. Mobile tablet devices can however be used though through the Wi-Fi connection, and all devices should be muted. Password details are available in the gallery for anyone wanting to connect to the Assembly's Wi-Fi network, and no recordings or photographs may be taken. Can I remind members also about the protocols regarding the use of electronic devices? Switch all mobile devices off or to airplane mode and deactivate Wi-Fi connection. Please use tablet devices discreetly and in a way which does not interfere with proceedings, and be aware of the cameras when using the tablet device. So members, moving to item 1, apologies. Clerk, can you advise, please?
Shan Mulholland.
Shan Mulholland, apology, and all other members attending. Thank you. So members, chairperson's business then, just to say that the Minister was scheduled, members, to brief the committee at next week's meeting. However, I have been informed that due to the executive meeting time being changed, he will no longer be able to attend. The department has confirmed that Colin Boyle, Permanent Secretary, will still attend to give an overview of the Department for Communities at the meeting. That will be followed over the subsequent 3 weeks with grade 3 briefings. The other item then to mention is, have members any comment or are content to proceed on that basis? Go ahead, Kelly.
Could I just ask, is the executive committee, is that going to meet at the same time as this committee every week then? So that means we'll never have the minister here?
Well, I'll ask the clerk what's her view on that, or what's the information on that.
We were advised that the meeting time for next week has changed, and that can happen, and that we will have to work together and keep in dialogue about a future appearance for the Minister.
So at this point it's a change in time rather than a fixed time, and we'll see how that transpires, but it will certainly be something we will have to have access to the Minister clearly. So okay, just to update members then that immediately following last week's meeting a request was lodged with the Department for officials to attend a meeting to brief on the Department's budget. The Department has confirmed that the Deputy Secretary of Corporate Services Group will be attending the committee on March 7th, and the Department for Communities budget will be a core part of her briefing. On the issue of budgets, members, you have been provided there at page 6 with documents on the Budget Bill 2024. Due to the urgent need for the bill to be progressed through accelerated passage earlier this week, I did speak only very briefly in the second stage of the debate, making the point the committee had not had any real engagement or information relating to the bill, and expressed the need for clarity on the budget settlement, its impact on the department, and that we would hope that a more timely process will certainly apply in the future. I think that was widely expressed. The bill documents in the committee packs are really for information only at this stage, and I would propose that we consider these again at the departmental budget briefing on the 7th of March. Also, just to flag up to members in relation to the first day brief has also been sent through in your table papers. However, that's really sent through for members to get early sight of that, and we will put that back on for next week's meeting as well. So that will be going back on for next week's meeting, and we can deal with it then. So are members content with that approach? Yeah, thank you. Just to advise further then that we will receive a briefing from the Assembly Research Public Financial Security Scrutiny Unit in closed session at the end of our meeting today. That will be useful for us in advance of being briefed by department officials on the budget over the coming weeks. I would ask that if you can, that you stay on for that briefing, and I will adjourn the meeting as usual after the last agenda item. Suggest that we'll take a short comfort break, and then we'll get the RAISE officials to join us. And finally, members, I wish to advise that I've been invited to attend an event as chairperson in the Ardone Theatre in Enniskillen as part of the Enniskillen Drama Festival. So just let members know that. Item 3, members, the draft minutes. I refer you to the minutes which are at page 71 of your meeting pack there. Clerk, is there an issue in the minutes that you wish to highlight?
Day and year at the top of page 71 need to be corrected to Thursday in 2024.
Okay, thank you. Members content?
Agreed.
Any other comments on the minutes, members? Are members therefore content to agree the minutes of 15th of February 2024 as drafted?
Agreed.
Okay, thank you, members. Moving on to item 4 then, members' correspondence. I refer you to the correspondence memo at page 89 of the main meeting pack. Are members content to action all other correspondence as outlined on the correspondence memo at page 89 of the main pack, and the table correspondence then is at page 3 of your table pack. So Kelly, I think first, and then Andy.
Thank you very much, Chair. I just want to highlight to people that probably all of us have received communications from the individual who's written to us in the second piece of correspondence. But as an outcome of that, I know that we've said for information and review. I was just wondering, the person has asked about the disability legislation, but importantly we haven't heard anything yet about the disability strategy. Could we maybe ask the Minister for an update on all of those social strategies?
Yeah, I would certainly. Members agreed with that?
Yep.
Yeah, Andy?
Yeah, it's on the same point, Chair. I was just going to reinforce that, the disability strategy, to get an update on that, and also maybe to hear from the department. I know we're going to get the briefings around plans around the wider disability legislation.
Yep, absolutely. Brian?
Can I just seek clarity then, in terms of the Northern Ireland Federation of Housing Associations? Certainly, I received the correspondence directly. I was planning to meet with, I think it's Seamus. Are we inviting him to the committee then, or I'm not clear. It just says that we will consider it.
So
if that represents all the housing associations, the federation.
Yeah,
Most, yeah.
Sean, are you looking at?
I was just going to say it'll be for members to decide at the planning day whenever we look forward to the forward work programme and start to schedule briefings in.
Yeah.
Okay.
And my thinking on that was that housing is a key issue and probably will be one of those issues we will want to be putting in very prominently into the forward work programme. Would be my view of it. If members, I think, would that be what you're suggesting?
Well, I mean, I don't mind meeting people individually, but if we're going to be meeting them collectively, obviously that'll save time for us all. When's that planning day then?
So the plan that was discussed last week, the forward work programme, is for weeks 4, 5 and 6 meetings that the committee will hear from the deputy secretaries of the department, and then the weeks that follow that, then it would be the key stakeholder groups that the committee will get briefings from, and we can schedule those in based on the priorities. So everyone that we're proposing to reply is, that's a holding line that we will go back to and offer them then briefing opportunities from weeks 7, 8 and 9.
Okay.
Okay, content with that?
Yeah, thank you.
Who's content with that, Ciara?
Obviously I would agree with Kelly and Andy in regards the disability rights and the need to be looking at the new disability strategy and see where that and how important that is, given that 1 in 4 people do have a disability. With particular reference to NICFA's letter, obviously we're clear, and I think all of us, in understanding the request for a standalone outcome in the programme for government, which is critically important, and as they also highlighted the need for a multi-annual budget. Also, the housing supply strategy is critical in reference to addressing our homelessness, and then likewise, and we're well aware of supporting people, the excellent work that they do, and how that budget has remained the same with no uplift. I think 1 uplift in 16 years. So, is it possible to request, I think, early on a meeting with the committee on housing specifically?
Certainly, right. We'll add that in then, requesting week 7. Yeah.
Thank you. The other one that the couple, and I did also obviously I want to associate with the remarks around the disability one. I think that is a key one, and a good letter in that sense, and welcome letter in that sense. The other one I wanted just to flag was the Armagh Papers Club letter there around that. What looks like obviously a huge disparity in funding levels. I was quite struck by it, I have to say. I didn't. So I think that's one that at some point we will certainly look at. And I also just wanted to note the importance of the neighbourhood renewal letter there as well. That's going to be a key area, I think, for us moving forward. So hopefully we can get that one scheduled as well. Kelly?
Right, Chair, I just wonder, are you moving on to the tabled correspondence as well?
Yes, I'm moving on. I'll just finish on that and then we'll go to tabled. So on the main pack, any other comments, members? Okay, and then tabled correspondence. And I have already mentioned that the neighbourhood renewal one off the table. So go ahead, Kelly.
To be honest, I was absolutely delighted the other day in the chamber when the Minister did mention about the improvements, or the commitment, to sign language. However, I would like to ensure that there's cross-departmental working on this. As a person, I have to declare an interest as a person who's a member of the deaf community. I'm very keen that at the same time education know that the signature project to bring through the sign language GCSE is ongoing. I would like, if everyone agrees, Chair, if we could write to the Minister to ask how his commitments to sign language will coalesce with the plans with the Department of Education has to bring in GCSEs, because providing a range of interpreters is wonderful, but you know, it's what other jobs are going to be available for them, and will that be built into the curriculum piece?
Yeah, and the other thing that struck me from the debate the other day, and I also welcomed the Minister's thing, the thing I didn't get time to raise the other day was around the issue, I had raised the issue about Irish Sign Language and British Sign Language, but rural, harder to reach deaf community is something that I think needs to be also considered quite strongly within the Daniel.
And Chair, I note in the pack that licensing is to come up, so I just want to declare an interest as early as possible as a director of a company that owns a licensed premises, just at this point.
Okay, thank you, Daniel. Okay, members, so are members then content with the main pack and also content with the table pack correspondence?
Great.
Can I seek clarification? Sorry, Chair.
Yes.
So, sorry, go ahead.
Sorry, Chair, just in relation to the first day brief, and obviously there's a lot in there around key priorities and stuff, but obviously there's a mention of welfare mitigations, and it's a key area I think all of us have spoke about and highlighted, particularly carers, and there's a number of recommendations. So in terms of our forward work plan, I'd be keen to get a better understanding of where the department is there. I know budgetary pressures is going to make things very challenging, but it'd be good to get an understanding of what the department's thinking is on that.
A letter seeking clarification from the department.
Yeah.
And sorry, the other question I just wanted to clarify in terms of Kelly's request for an update from the Minister and the commitment to sign language. Do you also want that to include a question on the rural, harder to reach members of the deaf community? Right, thank you.
So members content then with table papers, table correspondence?
Agreed.
Thank you very much then. So moving on then, members, to agenda item 5, and this is the Examiner of Statutory Rules report. It's on page 137 of your pack there. So the Examiner has drawn the committee's attention to the following rules for breach of the 21-day rule. SR 2022-172, income related benefits, local welfare provision, disregard, amendment regulations, Northern Ireland 2022. SR 2022-177, the child support amendments relating to electronic communications order, NI 2022. SR 2022-178, the child support amendments relating to electronic communications order 2022. SR 2022-215, the social fund winter fuel payment temporary increase regulations 2022. SR 2022-223, the Universal Credit Administrative Earnings Threshold Amendment Regulations NI 2022, SR 2023-086, the Social Fund, Maternity and Funeral Expenses, General and Social Security Claims and Payments Amendment Regulations NI 2023. The Examiner, members, is content that the Department has, on this occasion, provided a satisfactory explanation for those breaches. The Examiner also draws our attention to the following rules which contained drafting errors. SR 2023-007, the Occupational Pension Schemes, Collective Money Purchase Schemes, Regulations NI 2023 revoked, and SR 2023-117, the Occupational Pension Schemes, Collective Money Purchase Schemes number 2, Regulations NI 2023. The Examiner reports that the Department acknowledged the errors and that the appropriate corrections to SR 2023-117 has been made. Have members any comments, or are they content to note the ESR report?
Content to note, yeah.
Thank you, members. Item agenda 6 then is statutory rules. So we're moving now into the full consideration of the block of statutory rules that we have in front of us today, members.
Can I just declare an interest as a charity trustee and a private sector landlord before we get into those SRs?
Yeah, and I also am involved in several community groups and also a private landlord as well. So I'll declare that as well. Any other?
And also Niscon the Jericho registered as a charity.
Yeah.
And chair to a company director that owns multiple properties that is leased.
Thank you. Kelly?
I think just probably alongside any of us, as declared last week, member of the Nilgosh pension scheme that will be dealt with later.
Yep, okay. Thank you for that, members. So then we're moving, before I invite officials to the table, members, I would like to clarify the process that we'll adopt today. In your pack, starting at page 203, you have been provided with the statutory rules which have been laid over the last couple of years or so. These include a number of rules that were subject to the confirmatory procedure. We have a number of officials in attendance today from the department. Should any members have any questions in relation to any of these rules, the officials will give a brief outline of each rule before I put the question to members on whether they are content to agree the rule. So, the first one we're considering is SR 2022-294, the Charities Edge Hill Theological College Scheme, Order NI 2022, page 203. So I'd now like to invite Colleen Bell and Gerard Flynn, and they are both policy leads from the Voluntary and Community Division, to the table, and they will be dealing with the SR on charities. So I'd like to welcome both of you, Colleen and Gerard, to the meeting, and we'll be grateful if you would give us a summary of the intention behind this rule. Thank you.
Morning, Chair. Thank you.
Morning.
Thank you, members. I will just give a brief overview of the statutory rule in respect of the Edge Hill Theological College Scheme. The statutory rule was made in accordance with Section 32(2) of the Charities Act Northern Ireland 2008. Its purpose is to give effect to a scheme made by the Charity Commission for Northern Ireland in accordance with Section 32(1) of the Act. The Edge Hill Governors are the governing body for the Edge Hill College, which was incorporated by statute as a charity under the Methodist College Act Northern Ireland 1928 and is treated as a charity pursuant to the Charities Act 2008 Transitional Provision Order Northern Ireland 2013. The Commission received an application for a scheme under Section 32 of the Act to amend the governing documents of the scheme. This was to provide for the transfer of the Edge Hill endowments to the statutory trustees and for the dissolution of the Edge Hill Governors. As the statutory regulator of charities with responsibility for such schemes, the Commission confirmed to the Department that it was satisfied that it was in the interest of the charity, and a scheme was made on the 10th of June 2022. The Departmental Solicitor's Office confirmed that a statutory rule under Section 32 was necessary to give the scheme effect, and this is subject to negative resolution. A Section 75 assessment was completed and no adverse impacts were identified. The Department is not required to consult on the statutory rule. The Commission, however, made a scheme in line with the requirements of the Act. It gave public notice on its proposal that the scheme was to be made and invited representations to be made in relation to it. The Commission published the draft scheme on its website for a month and invited comments from the public, and no comments were received. As the charity is created through statute, the changes to the governing documents set out in the scheme of the 10th of June 2022 must be given effect by an order made under Section 32.
Thank you, Colleen. Brian.
Probably not necessary, but I think I should probably declare I'm a member of the Methodist Church in Ireland.
Okay.
I just assume this has all been done with the consent of Edge Hill College in the Methodist
Yes,
Church. It's
yes,
not
they
been
have.
imposed on them, it's their request.
Yes.
Yeah, so that's fine.
Okay. Thank you. Thank you. So members then, do members have any objection to the rule? No objection, thank you. So then I put the question that the Committee for Communities has considered SR 2022-294, the Charities Edge Hill Theological College Scheme Order NI 2022, and has no objection to the rule. Are members agreed?
Agreed.
Great.
Thank you. So thank you, Colleen and Gerard, for your assistance with that rule, and I invite you to leave the table. I now invite Carol Reid to the table, and Carol is Policy Lead for Local Government and the Housing Regulation Division. So, members, this is agenda item 7 on page 212. It is SR 2023/72, the licensing, form of licence, amendment regulations, NI 2023. So, Carol, welcome to the meeting. Thank you for coming along. And would you go ahead, please, and give us your summary of the intention of this SR?
Yes, thank you, Chair. Thank you, members. So the licensing form of licence amendment regulations Northern Ireland 2023 were made under Article 33 of the Licensing Northern Ireland Order 1996, which regulates the retail sale of intoxicating liquor. They were brought into operation in May of last year and were subject to the negative resolution procedure. So as the title suggests, it's an amendment set of regulations. The original regulations prescribe the form of licence issued by a court authorising the retail sale of intoxicating liquor in a particular premises. So it's basically the information that legally needs to be included in a physical liquor licence. The need for the amendment came from the Licensing and Registration of Clubs Amendment Act Northern Ireland 2021, which made changes to the 1996 order. Some of those changes affected the information that should be or should not be included in a physical liquor licence, and 6 sections of the Act were involved there, so I'll run through those quite briefly.
Section 1 removed additional restrictions on permitted hours at Easter. That meant that any references in a liquor licence to Good Friday or Easter Sunday needed to be removed. Section 2 removed restrictions on late night opening on Sundays, so similarly references to that restriction needed to be removed. Section 3 allowed for further additional hours for pubs and hotels, and therefore a reference needed to be included to capture that detail in a licence. Section 10 added local producers of intoxicating liquor to the categories of premises which could be granted a liquor licence for off sales. And then hand in hand with that, Section 11 added an ability for licensed local producers in certain circumstances to sell for consumption on the premises. And it's important then that references to a new category of licence and any suitability order or authorisation granted is included in a licence. Finally, Section 15 allowed for underage functions in certain licensed premises, and similar to the previous ones, reference to any associated suitability orders or authorisations granted need to be included in an actual licence. So, Chair, it's very much practical outworkings of the 2021 Act.
And that has been in place now for some time, is that
It has
right?
been, yes.
And what's your assessment of how it's been operating in terms of the?
It would only be anecdotal at this stage with discussions with the court service, but there don't seem to be any issues with this part of it at all. It was the court service that had asked for it to be brought about now rather than waiting until ministers were in place again.
Okay. Any other questions?
As I said earlier, Chair, I have an interest to declare I'm a licensee holder or director of a company that owns a licence, but just for the wider sector, these are improvements that will help massively, and they're much welcome.
Kelly?
Absolutely welcome the SR coming through. It was hard work that we went through in this committee over many periods, and thank you very much to Carol and the team on that. One of the items that's coming up, I just wanted to check, so this will bring into force a lot of what we had agreed and the Minister had agreed in the previous mandate about the licensing. We were due to have a review. I'm just checking, Chair, to see when we're thinking about that's coming forward, because there's one piece that I think that we left out, and that was not necessarily to do with alcohol, it's to do with entertainment premises who were not given that extension of opening hours that liquor licensed premises are. So it's entertainment as opposed to...
This is public entertainment.
I know that's something that I think that we just failed to miss it or to include, but I'm just wondering about that review timescale.
Okay, not that I thought you might have asked this at all.
Sorry.
No, I have it sitting here. So the Section 43 review, Kelly, is I think the one that you're speaking to, and that was a requirement on the department to review the implementation and effectiveness of the Part 1 and Part 2 of the Act. Some members will know that the Act itself was commenced in a number of phases, and there were 5 phases in total. The requirement is that the first reports are published as soon as practicable after 3 years from the date of implementation. So, having considered the different dates, the determination has been it would be better to do 3 separate reports rather than waiting, because some of them were a good year so apart. The 2 a.m. opening that you will be referring to was in phase 1, so it will be the first report. Work is well underway within the department and with statisticians in terms of developing questionnaires and the approach that we're going to take to that. The intention at the minute is that would be published in June 2025, so that would allow for a full 3 years of data to be captured. The concern was that if we went any sooner than that, with the impact of COVID on the hospitality sector, we might just not get as much information as would be helpful.
Thank you very much. Thank you, Chair.
Thank you. Morris?
Thank you very much, Chair. Thank you very much for your explanations there. But just a wee question. I'm not au fait with alcohol, but is in the legislation that a distiller can sell on his premises?
That was a new category of licence that was added. Yes, they need to go through the court procedure to get a licence.
I would agree with that there. But have you any feedback of how successful that has been, or otherwise?
There's been some discussion, mostly with the like of the breweries, I think, the uptake. The last count we had from December 2023 was, I think, it'd be 14 or 15 in and around. Now, I didn't get a breakdown of whether they were distillers, cideries or breweries. A lot of the distillers would have already had a liquor licence in place due to their size, really. So I can't tell you exactly. I can aim to find out if you'd like to know exactly how many. But it's in the region in total of 3 different types of premises. It's in the region of about I say 13 to 15, I just can't recall.
Thanks very much. Thank you, Chair.
Thank you. Okay, then, do members have any objection to the rule?
No.
No, thank you. So I would ask that the Committee for Communities has considered SR 2023-72, the licensing form of licence amendment regulations NA 2023, and there's no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Thank you, Carol, for your assistance, and I now invite Heloise Brown.
Much.
And Heloise is Director of Social Housing Policy and Oversight to the table. And good morning, Heloise. Thank you. This is agenda item 8, members, and the housing renovation, etc. SR 2023/2, the housing renovations, etc. grants, grant limit amendment order NI 2023, page 225. So, Heloise, would you please go ahead and give us your summary of this one?
Thank you, Chair. So the housing renovation, etc. grant limit amendment order Northern Ireland 2022 increases the upper limits that are payable for the disabled facilities grant. So the original grant limit order, which came into operation in December 2003, set out the maximum amount payable for grants to renovate the home. In the case of disabled facilities grant, this was set at £25,000, with the stipulation that for any of the purposes specified in the legislation, the Housing Executive could, if it thinks fit, pay a further amount up to £50,000. So this order increases the maximum level of grant funding for adaptations to a private dwelling to enable people with disabilities to remain in their own home. So the consequence of the limits being set in legislation is they had not been uplifted since 2003. Furthermore, since the pandemic, there were significantly rising costs within the construction sector caused by a scarcity of materials and labour and supply chain issues. And as a result, the maximum grant levels were no longer adequate to cover the current costs of many of the adaptations required. This needed to be rectified and the upper limit increased to enable adaptations to be completed. In terms of how it may affect applicants, the upper end of the scale of required adaptations, applicants may have found themselves in receipt of a grant which didn't cover the actual costs of the required work under the previous legislation. They were required to cover any gap in funding themselves, and as applicants who qualify for the full grant will have been means tested, they would not have the ready access to funds to cover the gap. At the time of making the audit, there were approximately 50 disabled facility grant cases where the cost of work exceeded the maximum grant payable of £50,000, and we were expecting then that these numbers would increase in the immediate future. So the order increased the grant, standard level of grant to £35,000, with the maximum for specified purposes increased to £70,000 for those applications made on or after the 1st of February 2023. The regulations were equality, screened and rural impact assessed, and it was concluded that there were no significant impacts, and it was concluded that the time taken for consultation would not be required because the urgency was there to increase the grant limit to enable the adaptations to be made. So that sets out the rationale for the regulation.
Thank you, Heloise. And O'Kelly, you wanted to come in there?
Yes, Heloise, thank you very much, Chair. I'd written to the Chair and the Clerk in advance to say that I wanted to ask questions about this. I'm delighted about the increase, so it's not about that, but it's about the detail of what the increase applies for. I've had significant amount of work through my office on disabled facilities grants over the years, and one of the issues that I have is that the allocation of grant appears to be for a house as opposed to people with disabilities. So where there are 3 children or twins in a home, the amount of grant, to be honest, will exceed 70,000 because the allocation appears to be for the house as opposed to for the individual person's needs. So in the case I had where there were 3 disabled children within a family, the costs to meet the needs of each of those children's different disabilities exceeded 70,000, and that's going back a few years. So I'm delighted to see the 70,000, but could you clarify, is the grant for the house or the grant allocated per disabled person?
It will be per application, and what an occupational therapist can do is either do a joint application for people within a house, in which case that maximum grant would be 70,000, or they could do individual applications for each of the people within the house, in which case each individual application would be 70,000 if it meets the requirements of the legislation.
And does this regulation explain that well enough? I just wonder about that because I'd be very honest, the knowledge base locally within occupational therapists and teams that deal with disabled facilities grants doesn't convey that. I know that we had to push quite hard in a case of twins that the recognition for each individual child had to be acknowledged, and I'm just wondering, in the regulations it does say the maximum amount payable to grants to renovate the house as part of the background, when it should actually be the maximum payable grants to meet the needs of a person with disabilities. I'm just hoping that that will come forward. I'm delighted to hear that individuals can have up to 70,000 now. We know that the cumulative impact in a house we're tracking, for instance, or change of bathroom, may well suit a number of people, but it's when there's different disabilities that those can actually be met. I know it sounds like if you had multiples of 70,000 you may as well rebuild a house, but where there are specific necessary needs in order to keep people in their own homes, that we can react to that. So I would just ask then, I'm happy to support the regulation as it is because it's increasing the money, but if we could have clarification built into the guidance and the understanding about this, that it should be it can be considered per person in the home. Yeah, thank you.
Thank you, Kelly. Ciara?
Thank you, Heloise, for providing the detail, and obviously very much welcome, obviously, the increase in the Disabled Facilities Grant, as we're all aware, and there's a huge demand, and there's a lot of work. I'm sure all of us have been working closely with residents to support them, and obviously we have to do our best regarding ensuring that our homes are fit for purpose for someone with disability. I'm just aware that there's an ongoing review between with yourselves and the Department of Health on the Disabilities Facilities Grant, and the Patient and Client Council currently have out for consultation with individuals who have benefited from it. Could you, or even write to me with regard to what other stakeholders are being engaged in that process? Like, I'm conscious for the likes of Gable, a fantastic organisation that I know that I have worked closely with ones that are currently going through the process, and they do fantastic work. Are they going to be part of that engagement process going forward?
Yeah, thank you. I mean, we would certainly expect that we'll do more. I think what we're doing at the moment is the very sort of starting process of reviewing the grant as a whole. So it has started with that Patient Client Council survey. In terms of timescales, the timescale will depend very much on how big the review becomes and whether it needs changes to primary legislation. So we're working through these with the Department of Health and the Housing Executive to really scope that out. We have a terms of reference and we have a project board that's meeting, but we need to just scope out exactly sort of how much more we will do. And obviously if there are changes, wider changes proposed, there will be consultation, and we will focus that very much at the groups that will be wanting to input to this. There will be a strong disability focus if there's consultation.
Is it appropriate to ask when you have a finalised agreed terms of reference that we could be privy to that terms of reference for the review?
I will certainly check within the department.
Thank you, Louise.
Thank you, Deputy Chair. And Daniel?
Thank you very much, Chair, and thank you for that. This is welcome, and again, just declare my office deals with a lot of these and facilitates quite a significant number of people who are entitled to or in need of these extensions and wet rooms, bedrooms, etc. There's a number of challenges. Obviously, as an ageing population, there's bigger questions that we have about whether it's viable or appropriate to continue granting, and this isn't for this committee, but just as a wider point, granting planning permission for houses that have no downstairs facilities, given the huge numbers of the population at an age in their life that requires downstairs accommodation. So there's a wider debate and discussion needed in relation to that, because I know, and Militia will share this, as will Ciara, that in Strabane there's very few bungalows accommodation. The population is ageing, and it gets to a certain point where the person in the house requires this grant to meet their need, disablement. That aside, there's also a further challenge. The grant is hugely welcome. The increase is significant, very, very welcome. I'm a huge supporter of the scheme. I think it is very, very good. I've seen the huge benefits and improvements it brings to people's lives, particularly the carers that are struggling to help the person that is disabled. But there is a gap here. There's also people that are eligible for the grant. The grant is delivered, but ultimately once the bricks and mortar and the standard basic build is finished, they're required to fit the inside with flooring and painted and decorated and all the rest. And lighting or whatever. There's a substantial cost to that. Not everybody can afford it. And 9 times out of 10, my office, and I'm sure others, have had to try and find ways of getting that person other financial support to ensure that the accommodation, the extension, the renovation is fit for purpose for them to get into. And often it ends up delaying their transition into that space. So is there anything within this that has looked at that as well?
It hasn't at this point. It might be something that we could look at as part of the review, but the terms of the legislation are really that the grant is for the adaptation rather than any subsequent decoration. But we can certainly look at that as we go forward with the review.
It's just, sorry for interrupting, Chair, but it's just, standard practices is to provide flooring at least, and they don't cover it in the grant. It's just basic build and standard finish. But thank you. It is a great grant, by the way. So just.
Thank you, members. I'm going to go back to Kelly and then to Brian, and just if I could ask members just to bear in mind that we do have a fair few of these to get good engagement, but we do have 35 to get through. So as brief and succinct as possible, please, Kelly.
Thank you, Chair. I just wanted to reiterate Keir Ferguson's points with regards to the review. I will make an early days plea, and this is put it on the record, that the suppliers list and the issues with how people with disabilities are having to project manage these things is really causing a lot of mental health issues and stress out there. I have to say that Disabled Facilities Grant, to bring someone who has a disability having the excitement of getting their house renovated, but to have to deal and project manage construction workers who may or may not be on site on time or deliver what they're expected to do is really difficult. So in that review, if we can absolutely make sure that that suppliers list and how that's managed is considered. Thank you. Sorry, Chair.
Brian.
Well, to put it briefly, I know many of these housing grants operate within a designated budget. Has there been a corresponding uplift in the budget for these grants?
In the year the order was made, the housing executive bid for a larger amount to cover that larger amount of budget, and obviously we were aware that there would be demand for that because there were those applications that couldn't proceed because they were over the limit. So the bid was made at that time, and that has continued.
And Chair, through the Chair, do we know, has it been a 40% increase in the funding allocated to this programme?
I don't know off the top of my head, I'm afraid. I can certainly find out and come back.
Because we don't end up with fewer applications, being approved.
Happy to come back to you
on that.
Okay,
very briefly, Deputy
Just a brief comment, and I would agree with Daniel in relation to maybe looking at the refurbishment works, which is a substantial cost that can deter people from going forward. And just one other thing maybe to look at is particularly those that have to move out of their accommodation when the work's ongoing, they have no other choice due to it, and they need actually accommodation that can move into that is adapted to their needs, which is another barrier for them to participate in this process. So that's just another area if it could be considered as part of the review.
Okay, thank you, members. Then can I ask if members have any objection to the rule? No objection. I will then put the question that the Committee for Communities has considered SR 2023/2, the housing renovation, etc. grant limit amendment order NA 2023, and has no objection to the rule. Are we agreed?
Agreed.
Agreed. Thank you, members. Thank you, Heloise, for your assistance, and I now invite Julie Broadway, Policy Lead within Local Government and Housing Regulation, to come forward to the table, please. Moving on, members, to agenda item 9, SR 2023/48, the Coronavirus Act 2020, extension to provisions relating to local authority meetings, order NI 2023, and page 231. So, Julie, welcome to our meeting, and can you please outline for the committee the intention and requirement of the SR?
Section 78 of the Coronavirus Act gave the Department the power to make regulations to allow district councils to hold remote or hybrid meetings during the pandemic. And Section 78 was due to expire whenever the Coronavirus Act itself expired on the 24th of March 2022. So the previous minister had agreed that an extension order could be made to extend for 6 months Section 78 of the Coronavirus Act. There is a provision in the Coronavirus Act that allows provisions of the Act to be extended 6 months at a time. So the first extension order was approved by the Assembly on the 21st of March 2022, and it extended Section 78 to the 24th of September 2022. Since then, a number of extension orders have been made, and 3 of the orders are being considered by the committee today. SR 2023 number 48 extended section 78 to the 24th of March 2023. SR 2023 number 51 providing an extension until the 24th of September 2023. And the current extension order, SR 2023 number 140, extends until the 24th of March of this year. So the making of each extension order has ensured that councils have been able to continue holding remote and hybrid meetings, and the Minister is currently considering a further 6 months extension order. Obviously, these orders made under the Coronavirus Act are their temporary arrangements because they can only be made for 6 months at each time. In 2021, the Department had taken a bill through the Assembly, the Local Government Meetings and Performance Act, as is 2021, and that had a power to enable the Department to make regulations about remote and hybrid meetings. And again, this is something else that the Minister will be considering, whether a more permanent solution in relation to remote and hybrid meetings should be made.
Okay, thank you. And I suppose I do welcome the fact that I think it's one of the things that have come out of COVID that has merit, in the sense that people who are maybe would have had difficulty engaging with meetings, women, carers, people with disabilities, rural dwellers, a lot of people in a hybrid fashion would be able to. The only thing I suppose that concerns me is that the extensions are being taken under the Coronavirus Act. I think it was more appropriate to put those into a standalone, recognised act rather than using Coronavirus. I think that's the only concern for me. Wouldn't be something that would prevent me from being okay with the rule, but I think it's very important that we quickly move to a situation where that's done on its own merit rather than as a result of coronavirus. So is that going to be the plan?
And that is something that the Minister we'll be putting that to the Minister shortly, about making regulations under that 2021 Act.
Okay, Kelly.
Chair, thank you very much, Gilly. Gilly, can I just pick through that? So the 2021 Act, what was the name of that Act that you referred to?
It was the Local Government Meetings and Performance Act.
So that already
2021. So there's already an enabling power there for us to make regulations.
So can I just check? So the current SRs take us right up until the 24th of March 2024. That's with right. The SR 2023 140. The extension that you may be coming back to us on is for 6 months. Is that necessary because it will take time then to effect and bring forward the legislation for that Local Government Meeting and Performance Act to be?
This will give the Minister time to consider any regulations that he may wish to make under the 2021 Act.
To be honest, I'm with the Chair on this. I think that the benefits of hybrid working for maternity, paternity, adoption leave, we all know that none of us elected representatives qualify for any of that, so even being able to work from an office or home to come into meetings is invaluable. But I'm keen to see that work on a permanent basis be pushed forward. We already have it, that committees here in the Assembly can be hybrid, but we don't have it for our local government counterparts, so I'd be keen to see that working. I'm just wondering as well, Chair, that 24th of March, have we communicated that out to our councils to let them know of this cut-off point and the intention to extend that?
Once the Minister's currently considering this, and as soon as we get something back from the Minister, we will be writing to councils. Councils are very keen, as you can imagine, for this to be extended and have made representations to us.
And is there an intention for the Minister to have to consult on this? Because these obviously weren't needed to be consulted on.
No.
Okay.
The extension order, there wouldn't be a need. But if any regulations to be made under the 2021 Act would need to be consulted on. And we have carried out some engagement with councils about regulations.
So a future 6 month extension then will give time for that consultation period, and then we can go permanent. Thank you very much,
Chair. The Minister will be considering it.
Yeah.
Thank you. Okay, so have members any objection to the rule? No, thanks members. I therefore put the question that the Committee for Communities has considered SR 2023-48, the Coronavirus Act extension to provisions relating to local authority meetings, Order NI 2023, and recommends it to be approved by the Assembly. Are members agreed?
Agreed.
Thank you, members. Moving on then, members, to agenda item 10, SR 2023-51, the Coronavirus Act 2020, extension provisions relating to local authority meetings, number 2 order. NI 2023, and that's on page 237. So Julie, can I ask you again to please outline for the committee the intention and requirement for the SR? And if you can cover, like in general, some of the others and sort of group them, but that's okay. Yeah.
It's essentially the briefing that of previously. It's essentially, but that particular order will provide the extension, or provided rather the extension up to the 24th of September 2023.
Agreed.
So no objections to the rule?
No.
So I have to put it officially to the members that the Committee for Communities has considered SR 2023-51, the coronavirus. Sorry, Clerk, which one am I on here?
The coronavirus Act 2020.
2020, yes. Extension to provision, the Coronavirus Act 2020. So that's SR 2023-51. The Coronavirus Act 2020. Extension to provisions relating to local authority meetings. Number 2 order, NI 2023, and recommends that it be approved by the Assembly. Are we agreed?
Agreed.
Thank you, members. Item 23 for SR 2023/140. Coronavirus Act 2020. Extension to provisions relating to local authority meetings, number 3 order, NI 2023, page 243. Julie?
And that's the current extension order, and it covers to the 24th of March of this year.
Thank you very much. Have members any objection to the rule?
No.
No. Thank you. Members, then, can I put the question that the Committee for Communities has considered SR 2023-140, the Coronavirus Act 2020 extension provisions relating to local authority meetings, number 3 order, NI 2023, and recommends that it be approved by the Assembly. Are we agreed?
Agreed.
Thank you. Agenda item 12, SR 2023-78, the Local Government Performance Indicators and Standards Amendment Order, NI 2023, on page 249. Julie, can I ask you again, please outline briefly for the committee the intention requirement?
Yeah, the Local Government Act Northern Ireland 2014 includes provision to put in place a framework to support continuous improvement in the delivery of council services, and councils are required to gather information to assess improvement in their services and to report annually on that performance. And this is against indicators which they can either set themselves or that have been set by departments. Section 89 of the 2014 Act allows the Department for Communities to specify performance indicators and standards for councils in order to improve the exercise of their service, and this can also include standards which other departments have asked the Department for Communities to include in that order. So the Local Government Performance Indicators and Standards Order Northern Ireland 2015, which was made under Section 89 of the 2014 Act, includes performance indicators and standards on waste management, planning, and also on economic development activities. And the particular provisions about economic development were included at the request of the Department for the Economy. DFE has now requested that changes be made to the indicators and standards as a consequence of the introduction of a new phase of their Go For It programme. And that's what this particular order does. It actually makes minor changes to the targets that had been set out in the 2015 order. A consultation was carried out on the order, and to be honest, most people, in fact, there was no one who said that they would be against the increase or the changes in these targets. Also, DFE had carried out engagement with councils before the order was made.
Thank you. Kelly?
Just very quickly, thank you very much for that, Julie. I have no issue with this standing order. What I would ask is that the consultation period for this committee wasn't able to take place. I know that there's one thing I would like added into that, and that is progress and publication of local development plans. Is there a mechanism for us as this committee to feed into what the Minister will be adding in as performance indicators and standards going forward from the next financial year?
I think at this stage that there is no plans to change those indicators. Because DFC haven't actually set any of the indicators themselves, as other departments have asked for these to be set. And as I say, the planning would be one of the issues. We would consult with those other departments to see whether they want to make changes. And that's something that, of course, if we were proposing to make changes, the SL1, that we would be consulting with the committee at an early stage before the legislation would be made.
Thank you.
Thank you, Melissa.
Margaret, Chair. And just a note there on 3.2 that for the Department of the Economy had requested minor amendments to indicate and standards set out in the order in order to monitor the ongoing Invest NI programme. And that's to be welcomed in many respects, because we have at times fairly serious question marks over the Invest NI programme in terms of equality and the way that it has spread throughout the whole of the north of Ireland, and particularly I'm talking about the area that I represent, the northwest, the city of Derry, Strabane, and the rural hinterlands of the northwest as well too. And I'd hope to see that as a result of that we'll get a most clear picture in every respect that will allow us to be more strategic then in terms of encouraging Invest NI to ensure that they are treating us on an equal basis.
Thank you. So do members have any objection to this rule?
No.
Thank you, members. I'll put the question then that the Committee for Communities has considered SR 2023-78, the Local Government Performance Indicators and Standards Amendment Order NI 2023, and that we have no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 13, SR 2023-81. The Local Government Pension Scheme Amendment Regulations NI 2023 on page 256 of your pack, members. I believe William Dobbin will join you for the next two rules, Julie, and I now invite William, who is Policy Lead from Local Government and Housing Regulation, to come to the table. And Julie, can you please then outline for the committee intention for this next SR?
Yes, SR 2023 number 81 is essentially a technical amendment to the Local Government Pension Scheme regulations. They changed the revaluation date in the Local Government Pension Scheme from the 1st of April to the 6th of April, really to align to tax years. Under the Public Service Pensions Act 2014, a member's pensionable earnings under a care scheme must be revalued each year to keep up with inflation. But there was a misalignment between the date that was being used in the Local Government Pension Scheme and HMRC's date. So essentially this is just changing the date, so to align the two dates.
Okay, thank you. Members, any questions? No, thank you. Therefore, members, I will put the question that the Committee for Communities has considered SR 2023-81, the Local Government Pension Scheme Amendment Regulations NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 14, SR 2023-149, the Local Government Pension Scheme Amendment number 2 Regulations NI 23 on page 272. Julie, can you please go ahead again?
These regulations were made to address the findings of the MacLeod judgment. In that judgment, the Court of Appeal found that transitional protections the government had given older members of public service pension schemes when the schemes were reformed in 2015 had unlawfully discriminated against younger members on the grounds of age. And in the Local Government Pension Scheme NI, the MacLeod discrimination has been addressed by extending underpin protection to younger members of the scheme, whom the courts found had been treated unlawfully. In the Local Government Pension Scheme NI, the underpin is the means through which transitional protection was provided when the change happened from the final salary to a care scheme was introduced in 2015. All Local Government Pension Scheme members were moved to a reformed career average scheme on the 1st of April 2015. But for older members of the scheme, the pension payable was underpinned against what they would have built up if they still had been members of a final salary scheme. And the underpin compares the career average pension, what they would have got there, with the final salary, and an additional allowance then would be paid to top up. But of course, that underpin was for older members of the scheme. The appeal judgment found that it was discriminatory against younger members. So essentially what this set of regulations is doing, it's implementing the MacLeod remedy by extending that underpin to include younger members of the scheme.
Thank you, and very welcome, I think, in that sense. Brian, go ahead.
Just for the record, just to declare, I was a councillor from 2010 to 2022, so I was I was in the previous scheme and the new one. I don't know if I was considered an older or younger member, but anyway.
But the good old days, Brandon. Anyway, in any case.
Just through the NILGLOS scheme, just for the record.
No,
Okay.
thank you very much. Okay, members, do members have any objection to this rule?
No.
Thank you then. I put the question to you that the Committee for Communities has considered SR 2023-149, the Local Government Pension Scheme Amendment Number 2 Regulations, NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you. And thank you, Julie and William, for your assistance, and I invite you now to leave the table. For the next batch of rules then, we're going to David Polly, Director of Housing Supply Policy, and David, you're very welcome to our meeting. Members, this is agenda item 15, SR 2023/18, the Tenancy Deposit Schemes Amendment Regulations NI 2023, page 314. So, David, can I ask you to go ahead and outline for the committee the intention and requirement for the rule?
Thank you, Chair. Just to start at a different SR then, these all relate to the Private Tenancies Act 2022. So we also did SR 20, which was the commencement orders of sections 1 to 6. And that included things like, for the committee's information then, to bring in the certain provisions of the Private Tenancies Act, including notice of certain matters relating to tenancies, including past matters, receipts for cash payments relating to tenancies, provisions relating to tenancy deposits. The amount of a tenancy deposit shall be no more than 1 month's rent, and time, increasing the time limits for requirements.
David, I don't think we have this on today's list, and that's why we're all looking
doing
through
it for
our packs.
context.
Okay.
Okay, yes, okay. So that sets that context. Okay.
Sorry, sir, I should have explained that better.
No problem, go ahead.
So we did the commencement order for the Act, for the first 6 sections of the Act, and then 2 of those things needed different SRs. So those are the 2 which are on the list. So they are SR 18 and SR 19. So the SR 18 was the Tenancy Deposit Scheme Amendments Regulations, and this, on foot of the Act, have changed how long landlords have to protect deposits and provide information about this to their tenants. After a tenant pays a deposit, landlords now have up to 28 days to protect a tenancy deposit, which is an increase from 14 days, and 35 days to provide information about this protection, which is an increase from 28 days. Then, SR, do you want me to do the 2 together? Yep.
Yes, please.
SR 19 then is the Tenancy Information Regulations, and this prescribes the form of notice and the information a landlord must give a tenant relating to the granting of a private tenancy and any variation of that tenancy, and it reinstates the requirement of the previous Article 4 of the Private Tenancies NI Order 2006. So this is a statutory form which sets out things like what the rent is, when the term of the tenancy is, how you contact the landlord if something goes wrong with your house, and things like that.
Yep. Thank you, David. So any questions from members? No. So therefore I put the question in relation to that the Committee for Communities has considered SR 2023-18, the Tenancy Deposit Schemes Amendment Regulations NI 2023, and has no objection to the rule. Are we agreed?
Agreed.
Thank you. Moving on to agenda item 16, SR 2023-19, the Tenancy Information Regulations NI 2023, page 321. Clerk.
So David has spoken to that, and you can move directly to put the question.
Yep, thank you. Yeah, thank you. So, members, I go. Any objection to that rule, rule 19? No. Thank you. I'll go then to the question that the Committee for Communities has considered SR 2023-19, the Tenancy Information Regulations NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you. Moving on, members, and thank you for your perseverance, to item 17. SR 2023-104, the Registered Rents Increase Order NI 2023, page 335. And David, can I ask you again to outline for the committee the intention and requirement for the rule, and if there is a cohesion between and your group and some of those, that's fine. If you just let us know that's the case. So go ahead with your summary, please.
This one is separate. So this relates to statutory and controlled and protected tenancies. So this SR 104 makes provision for a 7% increase in registered rents for those statutory protected tenancies and properties that meet the housing fitness standard and that are entered on the rent register. So this is between about 300 or 400 of those statutory tenancies, which are very long standing. This was a decision made on the basis of a recommendation by the department's rent officer. This all goes back to old rent control which is very old. It's only for ones which meet the housing fitness standard. Anything with a certificate of fitness outstanding from a council does not get the rent increase. And the 7%, you'll see the rent officer recommended that there was a 7% rent increase, which was the same as the housing executive's rent increase that year.
Okay. Thank you. Members, any questions? No? And go ahead.
I suppose it's not specifically there, but obviously through the Private Tenancy Act and the issue of rent regulation, and I know in moving forward in phase 2, David, with the current measures, I know there was a number of them, the potential additional regulation in terms of rent regulations or rent decreases required for the department before the end of a period of the 12 months. Can you expand on that, or where they are?
That was Section 7 of the
Of rent regulation,
the Private Tenancies Act.
Yeah.
So the first part of that put a duty on the department to do a report on the impact of a rent reduction of up to 10% or a rent freeze for up to 4 years. The department commissioned the CIH, the Chartered Institute of Housing, to do that report, and we did that in time with the statutory deadline and led it at the Assembly. Then that's the first part of Section 7, then further gave us powers to make regulations on foot of that within certain parameters. But we had a year to do that, and there was no minister or executive or assembly in place. It required draft affirmative, so we did not make the regulations, and the power to make those regulations has lapsed under the sunset clause. The report, it's worth noting that the report CIH, which is an independent, it's the professional body of housing professionals, so a lot of the NHE and housing association staff and things that will be involved in it, or be members of it. It said that such rent controls as were in that bit of legislation in other places have led to an awful lot of loss of private rented sector supply, up to 20% in some places. So that is existing tenancies pushing the rents down, and where that has been tried, you lose a lot of rental supply. So it was not a recommendation of that report that we pursued that. It did then go and look at different types of ways of making rent fair, which is what our previous minister had said, that she wanted to make sure that rents were fair, and different ways of doing that.
So to review that, then obviously we need new legislation. And that's
So if you wanted to do rent, I mean, if you wanted to continue work to make sure that rents are fair, we would need to consider what our options are. That report is a good place to start to look at those. It talks about 3 generations of rent controls, forms of rent controls. Obviously other places are doing forms of rent controls, and then they would almost all need legislation.
And is that something that the department with the minister is something that can be looked at and maybe prioritised, given the fact that we're all conscious of the huge increase in rents? Our families are struggling. We've seen the report from the Trussell Trust yesterday, how families are struggling. 50-60% are going to food banks, etc., etc. We need to ensure and support the most vulnerable within our homes. And one of the issues, and I'm sure all of us have had residents where there are increases in rents and are not a few pound, they're hundreds of pound for those living in the private rented sector. And we need to prioritise those that are most vulnerable living within the private rented sector. So I think it needs to be a priority moving forward. And I'd be keen to hear, and probably may hear when the minister maybe comes to the table, the permanent secretary, is that a key priority? And obviously it would land to yourself to be working with us on it. But is that something you would consider would be part of the work plan and moving forward?
Well, I would answer that in 2 ways. I mean, immediately the LHA is being increased from the 1st of April, and in some places, I've checked the numbers, in some places it's gone up 44%, because it's been frozen for 4 years now, because it was surveyed. It was frozen for 2020, but it was surveyed before that. And rents in some places have increased by more, up to 10% 3 years in a row. So some of the rents, some of the LHA, which is a contribution from benefit, has gone up by up to 44%. And that's Belfast 2-bedroom. So that should give immediate help. And the CIH report pointed out that, there's 2 issues here. There's, if people are struggling with their rent, but it's costing more to increase to build houses, well then if you reduce the rent, then you get less houses and rents actually just go up another way. And what you really need to do is help people more with their rent. So that's happening. I mean, on the second point is where we go with phase 2. What we always talked about is phase 2. Yeah. We had already started a bit of work as to say, you know, what are our priorities now about phase 2? What do we want to do? You know, we were very focused on getting things finished. We still are finishing off the last bill. I mean, the electrical safety and the fire safety regulations still haven't come. So there's still bits we have to finish from phase 1. So we've started some work, and we're going to do some stakeholder engagement about where we go with phase 2. Obviously now we have a minister in place. And so we can now decide what to do with that and where we go with it and what we focus on.
Okay. Thank you, David.
Thank you, Kelly.
Just very quickly, just so I understand, David, and thank you very much for that. I know all the work that went into the Act. So what you're saying is that the review that we should have done to limit private rentals is moot now. Basically, that we've run out of time on that one. It would have to be new, clear legislation for that one.
Yeah, so you remember the amendment that went through?
Yeah.
Yes.
Very well.
Yeah, that gave us a duty to do a report, which we did, and then it gave us up to a year to do regulations within certain parameters that were laid out in that. But that year has passed, so yeah.
I think I'd be quite keen on a future work plan that we have a look at this. I visited the south and noted that there's certain requirements in order for private rentals to be able to increase rents by, and that's something I'd be very keen to examine.
They have rent pressure zones, which is a different model than the one that was in the amendment.
Yeah.
And Scotland have something similar too.
Thank you, Chair.
Are members content with Kelly's proposal, first of all? That was included in the clerk has noted. Do we have any objection, members, to the rule? No. Then I'll put the question that the Committee for Communities has considered SR 2023-104, the Registered Rents Increase Order NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you. David, thank you for your assistance, and you're invited to leave the table. For the next rule then, I invite forward David Tarr, Director, Social Security Policy, Legislation and Decision Making Division, and Nicola Boyle. And Nicola is Policy Lead in the Social Security Policy, Legislation and Decision Making Division. Members, this is item 18 on our agenda, SR 2023-189, the Child Support Management of Payments and Arrears Amendments Regulations NI 2023, which are contained at page 341. David, can I welcome you both to the meeting this morning and ask you to outline for the committee the intention and requirement for this rule, please.
Good morning, Chair. Good morning, members. So these regulations amend the Child Support Management of Payments and Arrears Regulations Northern Ireland 2009 to make provision for further circumstances in which the Department may extinguish liability in respect of arrears of child support maintenance where it appears to the Department that it would be unfair or otherwise inappropriate to enforce liability in respect of those arrears. Arrears will only be extinguished where the amount outstanding is less than £7. The regulations were made for the first time on the 16th of November 2023 and they come into operation in 26th of February this month.
Thank you. Members, any questions?
No.
Any objection to the rule, members? No. Therefore, I'll put the question that the Committee for Communities has considered SR 2023-189, the Child Support Management of Payments and Arrears Amendment Regulations NI 2023, and recommends that it be approved by the Assembly. Are members agreed?
Agreed.
Thank you, members, and thank you, David and Nicola, for your assistance with that rule. For the next batch of rules, then, I will now invite Hayley Ward, Policy Lead, Social Security Policy, Legislation and Decision Making Division, to join David at the table, please. And Hayley, you are very welcome. Members, this is agenda item 19, SR 2023-2009. The Pensions Dashboards Number 2 Regulations NI 2023, page 350. David or Hayley, can I ask either of you to outline for the committee the intention and requirement for this rule?
Yes, so this statutory rule sets out requirements that need to be in place to enable pensions dashboard services to operate effectively under the Pensions Northern Ireland Order 2005. Pensions dashboard services are an electronic communication service which will allow individuals to see their pensions information, including the state pension, in one place online. Pensions dashboard services will help individuals to be reunited with lost pensions and support people in better planning for their retirement. The rule requires occupational pension schemes to connect to the dashboards and to be ready to respond to data requests according to statutory deadlines and in the correct data format. It sets out the various requirements which pensions dashboard services and the providers of these services will need to meet and continue to meet to be qualifying pensions dashboard services. It sets out a robust and effective enforcement regime which allows the pensions regulator to take appropriate enforcement action in the case of a failure to adhere to any of the proposed requirements. It also enables the Money and Pension Service to share information with the pensions regulator in connection with the functions under these regulations. The rules provides a single connection deadline of 31st of October 2026. The rule before you today revokes and re-enacts the Pensions Dashboard Regulations Northern Ireland 2023, which will otherwise cease to have effect by virtue of Article 288, Section 2 of the Pensions Northern Ireland Order 2005. And then such a rule was made on the 6th of December 2023 and became operational on the 8th of December.
Can I just ask, is there a single point of contact where people can go to the department to check across a range of pension providers or employers or whoever to find their pension? And I have seen cases where pensions have been lost, so it's a welcome improvement. So is there a single point of contact or a phone number?
Within the department, so the Money and Pension Service and the Pension Regulator provide a UK-wide service, and we can certainly direct individuals to that. Within the department, we have responsibility for maintaining the legislation in parity with GB, but there's UK-wide regulators, and they have the responsibility to ensure the pension services are available for people and people can access their information.
Yeah, I suggest maybe that there's a public information element to that, considered I don't think people know that enough or where to start that journey, and I think that would be an important element.
Certainly we can take up with the Money and Pension Service, yes.
Yep, thank you. Brian, and then I'm going to Kelly.
Yep, it was similar to what you asked, Chair. Is this pension dashboard live now, or it's something that you're working on? I saw there was future tense in the wording there.
Yeah.
Right.
It's just the regulations in order to bring this into effect. So the connection deadline is 31st of October 2026. So all the pension providers should have signed up and have the information live by that date. That's the intention at this point.
It's still some time away, but it's as the Chair said, it's just I had this experience myself, having to go through when you change employers, trying to bring them all together. I brought them together through Nest, which I think is a statutory link, isn't that right? Yeah, and but yeah, you could easily lose track of one or two over the years. Yeah.
Absolutely, and that's the intention of the dashboards. You know, it is to bring all those together so that if you do lose a pension, then you won't effectively lose it anymore because you'll be able to see it online.
Okay, great, thank you.
Thank you, Kelly.
Just very quick question. I was a bit confused by the dates. So there was a mention of the 8th of December. What was that 8th of December for? And then I know that everybody has to be registered, has to be on the scheme by the 31st of October 2026. But what does the 8th of December mean?
That's whenever the regulations became operational. Okay. So originally, the dashboard regulations were made on the 25th of November 2022, but because they're confirmatory, we weren't able to get them confirmed by the Assembly. So we have been revoking and reenacting them every 6 months. So that's the latest set that we have revoked and reenacted, and they need to be confirmed by June in order to get them confirmed.
And with this today, does that mean then the Minister can then bring this to the House and that's us? We won't need to renew in June. The other thing I wanted to ask is, absolutely delighted, to be honest, having worked in many different places. It'd be nice to find all my pensions. I'm just wondering, are we going to lead by example by ensuring that all government pensions, for instance, are brought into this a lot earlier than the 2026?
I'm not sure at the moment, but I can certainly take that away and have a look into it for you.
Thank you.
No worries.
Thank you. Brilliant work.
Morris? Oh, sorry, no, I had Ciara first, Morris. I'll come back to you. Sorry.
Well, I think obviously it's excellent news, and I think a lot of people will really, really appreciate this, where you can in one place find your pension. I'm just curious, just in relation to those that maybe work in Donegal but had previously worked in the north and stuff, is there going to be any future work on how you could be working with Ireland and here in the north, and there can be some other way of connecting your pensions? Is that something that's been raised or brought up, or?
Not as far as I'm aware at the moment. It's UK. It's on a UK basis, but it's something that we can certainly have a look into.
I think it is particularly living and working in Derry, and we have a lot of people that are working in Donegal, and there's a range of issues regarding double taxation, etc. And this would be another area. They may reside in Derry, but they're working, but and they have a number of pensions maybe through a lifetime, and this, I think it would be something for future reference to maybe that you could look into.
Yes, certainly. We will commit to going back to our UK counterparts and asking them to look at that.
Yeah, and I was going to come to that question as well, and actually there are, I believe, memorandum of understanding in place around data, which would help to streamline that process, hopefully. Morris.
Thanks, Chair. Chair, I'll be brief. Would this legislation cover people who have opted out of their pension and then at a later date opted back in again? Will that be able to be traced through this system as well?
Yeah, as far as I'm aware, yeah.
Just we have some cases in the office about that. So thanks very much. Thank you, Chair.
Thank you. Members, any objection to the rule?
No.
No, thank you. Then I put the question that the Committee for Communities has considered SR 2023-209, the Pensions Dashboards Number 2 Regulations NI 2023, and recommends that it be approved by the Assembly. Are members agreed?
Agreed.
Thank you, members. Agenda item 20, SR 2023-158, the Occupational Pension Schemes, Administration, Investment, Charges and Government, Amendment Number 2 Regulations NI 2023, page 421. David and Haley, can one of you go ahead and outline?
Yes. Thank you, Chair. So the Department will request that the Committee does not consider this SR today. The Department is planning to revoke and remake the SR to ensure there is no disruption with parity with regard to the Occupational Pension Schemes regulations, and an SL1 on this, the remake will be referred to the Committee for consideration. This is one of a package of occupational pensions SRs that are all due to expire in the next coming weeks. So rather than, quite frankly, give us time to properly brief Minister and schedule these rules for for debate and to be confirmed by the Assembly, we just thought it was prudent just to revoke and remake. So the SL1 will be coming to the Committee, and you'll have a full opportunity to consider in due course.
Okay, thank you. Therefore, I'm not going to put any question in relation to that, members. So moving on to agenda item 21, SR 2022-300, the Occupational Pensions Revaluation Order, NI 2022, at page 454. David or Haley, go ahead again, please.
So when a person leaves a pension scheme early, their pension rights may be preserved until the person reaches pension age. To help protect the value of the pension in the intervening years, the pension must be revalued when the person reaches pension age. The Department is required annually to make its statutory rule to set out the percentages by which preserved pensions are to be revalued in the coming year. The revaluation percentages are updated annually with reference to the latest inflation figure for the preceding year ending on the 30th of September. The rule specifies the revaluation percentage for the revaluation period, 1st of January 2022 to 31st of December 2022, as 5.0%. The Department has no power to set a different percentage from Northern Ireland. We must align with those in Great Britain.
Okay. Technical?
Technical.
Very technical. Yep. Any questions, members? No. Any objections to the rule? No. Thank you, members. Then I put the question that the Committee for Communities has considered SR 2022-300, the Occupational Pensions Revaluation Order, NI 2022, and there's no objection to the rule. Are we agreed?
Agreed.
Thank you. Agenda item 22, SR 2023-22, the Pension Protection Fund and Occupational Pension Schemes Levy Ceiling Order, NI 2023, page 461. I'll go back to David and Haley, please.
This statutory rule specifies the Pension Protection Fund levy ceiling for the financial year beginning on the 1st of April 2023. The levy ceiling is a control mechanism which ensures the amount raised through the pension protection levies by the fund does not exceed a prescribed maximum. The rule is expected to set the amount of the levy ceiling for the 2023-24 year at £1,246,964,705. Whenever the Secretary of State for Work and Pensions makes a levy ceiling order under the Pensions Act 2004, the Department for Communities is empowered to make a corresponding order. The Department has no power to set different amounts for Northern Ireland. This statutory rule was made on the 23rd of February and became operational on the 31st of March 2023.
Thank you, members. Any questions?
No.
Any objections?
No.
Then I put the question that the Committee for Communities has considered SR 2023, /22, the Pension Protection Fund and Occupational Pension Schemes Levy Ceiling Order, NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 23, SR 2023-29, the Guaranteed Minimum Pensions Increase Order, NI 2023, on page 467. And back to David and Haley, please.
So this statutory rule specifies the percentage by which the guaranteed minimum pension element of an individual's occupational pension entitlement is increased with effect from the 6th of April 2023. Before April 1997, the Defined Benefit Occupational Pension Scheme contracted out of the State Earnings Related Scheme had to provide a guaranteed minimum pension. Entitlement to a guaranteed minimum pension gives a member of a contracted out occupational pension scheme the right to receive a defined minimum amount of earnings related pension from the scheme. The amount of the guaranteed minimum pension on retirement equates to the pension to which the member would have been entitled had he or she remained in the state earnings related scheme. Under Section 109 of the Pension Schemes Act 1993, the Secretary of State for Work and Pensions is required in each tax year to review the general level of prices in the period of 12 months since the last review. If the review concludes the prices have increased at the end of the period under review, the Secretary of State is required to make an order specifying the percentage by which that part of the guaranteed minimum pension attributable to earnings factors between the tax years 1988 to 89 and 1996 to 97 is to be increased. The Secretary of State for Work and Pensions has made an order under Section 109, subsection 4 of the Pension Scheme Act 1993, prescribing an increase of 3%. This SR will obviously apply for Northern Ireland, and again, the Department has no power to set a different percentage for Northern Ireland.
Thank you, David. Members, any questions?
No.
Any objections?
No.
No.
I will therefore put the question that the Committee for Communities has considered SR 2023-29, the Guaranteed Minimum Pension Increase Order NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Agenda item 24, SR 2023-41, Pension Protection Fund, Compensation and Occupational Pension Schemes, Fraud Compensation Payments, Amendment, Regulations NI 2023 on page 473. David and Haley, please go ahead again.
So this statutory rule amends existing regulations so that the compensation paid to child dependents of Pension Protection Fund members does not cease due to a break of more than 12 months between periods of full-time education. It allows dependent children to continue to receive compensation payments if they begin the new qualifying course before reaching the age of 23. The rule also allows the Fraud Compensation Fund to make interim payments to pension schemes that have exhausted their assets in order to cover the cost of making an application for compensation from the Fraud Compensation Fund. This amendment allows the Fraud Compensation Fund to progress applications from the set of schemes which were found to be eligible for fraud compensation payments. And this rule is currently in effect, came in from the 6th of April 2023.
Okay, any questions? Any objections? No. Thank you, members. I therefore put the question that the Committee for Communities has considered SR 2023-41, the Pension Protection Fund, Compensation and Occupational Pension Schemes, Fraud Compensation Payments, Amendment Regulations, NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Agenda item 25, SR 2023-193, the Occupational Pensions Revaluation Order, NI 2023, page 480. Go ahead, David, please.
When a person leaves a pension scheme early, their pension rights may be preserved until the person reaches pension age. To help protect the value of the pension in the intervening years, the pension must be revalued when the person reaches pension age. The revaluation percentages are the same in Northern Ireland as they are in GB, and the Department has no power to set a different percentage for Northern Ireland. This statutory rule became operational on the 1st of January 2024. So again, another technical change, Chair. Really.
Thank you. Have members any objection or questions?
No.
Thank you. Members, then I'll put the question that the Committee for Communities has considered SR 2023-193, the Occupational Pensions Revaluation Order, NI 2023, and we have no objection to the rule. Are members agreed?
Agreed.
Agenda item 26, SR 2022-297, the State Pension Debits and Credits Revaluation Order, NI 2022, page 487. And David and Haley, back to yourselves.
Well, the Pensions Act Northern Ireland 2015 introduced a new state pension for people reaching state pension age on or after 6th of April 2016. This statutory rule revalues new state pension scheme debits and credits to reflect price increases since the debit or credit was created. The part of a person's new state pension based on their pre-April 2016 contribution record that exceeds the full rate of the new state pension as at the 6th of April 2016 is commonly referred to as a protected payment. Under the new state pension, a person's protected payment may be shareable in divorce proceedings where those proceedings started on or after the 6th of April 2016. Where a pension sharing order takes effect before either or both parties have reached their respective state pension ages, the debit and or credit will be revalued according to the percentage increase in the general level of prices. At state pension age, the transferor's protected payment will be reduced by the debit and the transferee's new state pension will be increased by a credit of the same amount as the debit. The Secretary of State for Work and Pensions is required to review the general level of prices in each year. If they have increased, the Secretary of State is required to make an order specifying the percentage of their amount by which the relevant debits and credits are to be increased in order to make up any fall in their value during the review. The Secretary of State has specified a revaluing percentage of 10.1% for the 2022-23 tax year, in line with the Consumer Prices Index. The Department for Communities is empowered to make a corresponding order and has no power to set an alternative rate for people in Northern Ireland.
Thank you, David. Any questions, members?
No.
Any objections?
No.
Therefore, I put the question that the Committee for Communities has considered SR 2022-297, the State Pension Debits and Credits Revaluation Order NI 2022, and has no objection to the rule. Are members agreed?
Agreed.
Item 27, members, SR 2022-298, State Pension Revaluation for Transitional Pensions Order NI 2022, page 494 of your pack. David and Haley, please, or go back to yourselves.
Okay. I'll let you read this one.
The Pensions Act, NI 2015 introduced new state pension for people reaching state pension age on or after the 6th of April 2016. The statutory rule revalues protected payments to reflect increases in the general level of prices since the 6th of April 2016. The protected payment is part of the person's new state pension based on their pre-6th of April 2016 national insurance contributions, which exceeds the full rate of the new state pension, which was $155.65, as of the 6th of April 2016. Once they're in payment, protected payments are increased in line with prices through annual uprating. In the interval between the 6th of April 2016 and when a person reaches state pension age, the protected payment is also price protected by way of revaluation. The Secretary of State for Work and Pensions is required to review the general level of prices annually. If they have increased, the Secretary of State is required to make an order specifying the percentage increase. The Secretary of State has specified a revaluing percentage of 23.5% by reference to the Consumer Prices Indices from this April 2016 to September 2022. The Department is empowered to make a corresponding order. There's no power for the Department to set an alternative rate.
Thank you, Haley. Members, any questions? Any objections? No, thank you. Therefore, I put the question that the Committee for Communities has considered SR 2022-298, the State Pension Revaluation for Transitional Pensions Order NI 2022, and has no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 28, SR 2023-194, State Pension Revaluation for Transitional Pensions Order 2023, page 501. And Haley or David? Haley, go ahead.
This is exactly the same as the previous one, only it's the following year. So if I just go through the rate then.
Agreed.
Do we need to go through the detail of it?
Only if members want to hear the differential in the
There's
rate.
different rate types.
Different rate, yeah, but to get the rate just yet?
Yeah.
Thank you.
So the revaluing percentage for this SR is 31.7% by reference of the CPI, or Consumer Price Index. And the Department is empowered to make a corresponding order in line.
Thank you, Haley. Any questions or objections? Question, Brian?
So it's always referring back to the 2016 rate then, that's why the percent, it doesn't just refer to how much it's increased each year then?
Yes, it's just going back because it's the new state pension.
Right. Okay, it's just strange, but it's going back to that as a reference point then, whatever?
Yeah.
Okay.
Yeah, rather than back to the last change.
Mm-hmm.
Yeah. Okay, members, any other questions or any objection to this rule? No, thank you. I'll then put the question that the Committee for Communities has considered SR 2023-194, the State Pension Revaluation for Transitional Pensions Order 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you. Agenda item 29, SR 2023-195, State Pension Debits and Credits Revaluation Order NI 2023, page 508. Haley.
Okay, so we've covered the 2022 order for this. So if the Chair is happy, I'll just go over the new rate
Yep,
for 2023,
please.
if that's
Fine,
okay.
yeah.
So the revaluing percentage is 6.7% for the 23-24 tax year, in line with the Consumer Price Index. So the statutory rule was made on the 28th of November 2023 and became operational on the 20th of December.
Thank you, Haley. Members, questions? No. Objections? No. Therefore, I put the question that the Committee for Communities has considered SR 2023-195, State Pension Debits and Credits Revaluation Order, and has no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 30, SR 2022-301, the Pensions 2005 Order, Disclosure of Restricted Information by the Pensions Regulator, Amendment of Specified Persons Order NI 2022 on page 515. So David or Haley, please go ahead.
Yes, so the statutory rule enables the pension regulator to disclose restricted information to the Money and Pension Service in relation to its pension dashboard rule and to support delivery of pension dashboard services. Under the Pensions Northern Ireland Order 2005, the pension regulator is subject to a restricted information regime. This means that any information the pension regulator obtains under its functions cannot be disclosed except under certain circumstances or unless it's specifically enabled to do so. The rule adds the Money and Pension Service to the list of bodies in Schedule 3 to the 2005 order to whom the pension regulator can disclose its restricted information for the purpose of facilitating the exercise of the Money and Pension Service pension dashboard functions. The rule enables the disclosure of restricted information to the Money and Pension Service where the pension regulator considers disclosure would enable or assist the Money and Pension Service to exercise its functions relating to pension dashboard services and the dashboard ecosystem under Section 31A of the Financial Guidance and Claims Act 2018. The statutory rule was made on the 7th of December 22 and became operational on the 28th of December 22.
Thank you. Members, any questions? Yes, Kelly?
I was just going to say, this is a replication across the whole of the UK. Given Ciara's question earlier, how will the information, for instance, if someone has a pension from a European country, say they've worked in Ireland or France or wherever, will that be able to be brought into this because there is no corresponding agreement?
I'm not aware of that, so I will come back. I'll have a wee check with the EU side of it.
Thank you. Any objection, members, to the rule? No. Sorry, go ahead,
Can I
Ciara.
just ask another question? Obviously, under GDPR, and given this regulation, for any information that is divulged, does the individuals be aware or be made aware?
I can double check that. I would assume that it will be signed, that will most likely be yes.
Anonymised, information anonymised, but under a
Yeah.
disclosure statement that they're all now made aware that.
Yeah, generally, I mean, any public authority releasing information, even to another public authority, we will let people know, you know, but certainly we can confirm that.
I will
for you.
confirm that. Yeah.
I'm far away from that.
Thank you. Members, any objection to this rule?
No.
No, thank you. Then put the question that the Committee for Communities has considered SR 2022-301, Pensions 2005 Order, Disclosure of Restricted Information by the Pensions Regulator, Amendment of Specified Persons Order NI 2022, and has no objection to the rule. Are members agreed?
Agreed.
Thank you very much. Haley, I believe you're now leaving us, and Helen Vaughan, who is Policy Lead for Social Security Policy Legislation Decision Making Division, will join David for the next set of rules. And thank you, Haley, and welcome to Helen. We're moving on to agenda item 31, SR 2023 number 4, or /4, the Housing Benefit and Universal Credit Housing Costs, Executive Determinations, Modification Regulations NI 2023, page 522. So can I ask one of you to outline the need for the rule?
Thank you, Chair. So this statutory rule provides for local housing allowance rates in 2023-24 to be retained at the same cash level as applied in April 2020. For housing benefit, the determination took effect from the 1st of April 2023, and for universal credit, the date that such determination took effect was the first Monday of the first tax year that follows the day on which the determination was made, which was the 10th of April 2023. In March 2020, as part of its response to the impact of COVID-19, the Department for Work and Pensions amended the Housing Benefit Universal Credit Housing Costs Executive Determination Regulations to increase the LHA rates, local housing allowance rates, to cover the lowest 30% of local rates from April 2020. Rates were maintained at the same cash levels for 2021-22 and 2022-23. The provisions contained within the statutory rule ensured that those levels continue to be maintained throughout 2023-24. Basically, it's the parity principle, as members will be aware. So this really is the local housing allowance rates that apply in housing benefit and universal credit for the current financial year for the remaining few weeks of the year this legislation remains in force. The next SR that you are being asked to consider are the new rates, which my colleague David Polly referred to earlier, which increases them substantially from April this year.
Okay.
It's just one element, obviously. We very much, I think everyone welcomed of that increase, but given that it was frozen for a few years and we have cost of living crisis and so many vulnerable people, and I know obviously you're waiting for GB and their decision, what they're doing. What's the likelihood, because anything that I'm reading, that we could be sitting again, ones in private rental sector, we're sitting for another couple of years where it's frozen, when is there the likelihood that it will now get back on track and increase on an annual basis to keep up with inflation and stuff? Do we have any say in that, or any way to inflate or pressurise it for that to happen? Because it's an absolute disgrace that people, yes, they were relieved now, but that didn't help them for 3 or 4 years when they were absolutely struggling. And we're not out of a cost of living crisis. Every report will show you that. So we need to ensure that this doesn't happen again, and that next year it's increased. Yep. How can we influence that?
I mean, I certainly I understand your concerns. As you will probably, or I assume, will appreciate, we have no influence directly on this. Pretty much we will get notified of the rates shortly before the announcement is made by the Chancellor. In terms of how the department can influence, the Minister, of course, can write to his counterparts, the Minister, Secretary of State for Work and Pensions, and highlight specific concerns. And that is something, obviously, we can take back to the Minister, or if the committee wishes to write. But the rates will be set by the Chancellor. We generally don't get much advance notice of what they will be. So the rates for this year, 2024-25, come into effect from 1st of April for housing benefit, and from the 8th of April for universal credit. Those rates were announced as part of the Chancellor's autumn statement in November 2023. So that's, honestly, I don't know exactly when the British government will make their announcement on when the next rates will be. It could be as part of the upcoming budget, which is scheduled for March, or it could be left for the autumn statement. Of course, there's a general election as well. But in terms of what we... Obviously, all the members will be aware of the principal parity, where we do generally follow what they do because of the costs of deviating from that. We can certainly, as a department, and it's not for me, obviously this is a decision for the Minister, of course, but we can ask the Minister to make representations if the committee was to wish to do that.
I would like to propose that we write to the Minister and ask that he could. I think we need to keep it constantly on the agenda. The right to DWP. To ensure that they should be considering it, no matter what who may be in government come the end of the year. But I think it's something we must regularly be putting pressure on to ensure that we don't have households in the private rented sector waiting for another 3 or 4 years to see if there's a local housing allowance, given how rent increases are increasing rapidly, and the trend is that they will continue to increase rapidly.
Thank you. So I have Kelly first, and I'll come back to you, Daniel.
I was just going to say I absolutely agree with Ciara's proposal there. It's something that, to be honest, I'm sick of getting questions asked in Westminster about this. But the other thing, now that the committee is back, can we perhaps write to the equivalent of ourselves in DW, the Committee for Work and Pensions, to ask them what communications that they have had with DWP on this matter? Because as David has rightly said, it is a Westminster decision that then we get notice of, at a very late notice of, but we certainly know the impact that it has here when we have, Trussell Trust have said 13% of people in absolute poverty, which means that they're spending 30% of their income on rent. So if we maybe could ask the equivalent committee if they've had any communications, or because the indications are that this year it's been released and there's an increase, but after that it was to freeze again. So yeah.
Okay. Daniel and Brian.
It comes a particular problem where there's very little supply to meet the considerable demand, and when there is little supply to meet the demand, there's landlords that are increasing private rents beyond all recognition, and we have seen, particularly in West Tyrone, a significant rise in the rent costs, and people are just becoming very stressed about it. They're ending up in arrears and then ultimately being asked to vacate, and then the problem really is that there's no alternative. There's certainly no executive or housing association properties available, because we all know the challenges of the waiting list. But it is a particular problem. I even have landlords coming to me with that haven't increased their rent, that are saying that people are struggling to make ends meet in that regard. So there is a particular problem there. I don't believe it is sufficient. I would say quite a lot of people in the private rented sector are in arrears because of the situation. It is just entirely unaffordable. It's a major problem, particularly for single parents, and I think it needs to be heavily focused on. So I'd support Ciara's proposal. I think it is the right one, and anywhere else where we can apply any pressure.
Thank you, Donald. Brian.
I'm just going to ask for clarity on a point, but certainly I've dealt with a number of cases where people in private rented sectors, the costs where the rent is put up, there is a discretionary payment, but I think it's a maximum of 2 years that the housing executive can apply to bridge the gap, and then people are having their tenancy terminated. You said there about it being, this relates to just the remainder of this 6 weeks or so of this financial year. And did you say there was an increase coming in next year, but you also talked about awaiting the budget statement? So
Yes. So the next SR the week before the committee deals with the rates that will take effect in April. And apply from April 2024 through to March 2025. I think Ciara's question is about future increases, right. And they're usually announced, and I do stand to be corrected, but my understanding they're usually announced by the Chancellor in his or her autumn statement, which is generally sort of October, November. So,
right. That's
but
for
of course, yeah,
26 we're awaiting.
Yeah.
But we know there's an increase for 24, 25.
There's definitely an increase. That's
right.
What this will apply, but that will apply and will through the incoming financial year. Beyond that, we don't know what will happen at this stage.
Thank you.
Very briefly, Daniel,
Just
please.
to follow up on that, Chair, and Brian rightly brings up the discretionary housing element that has been supplementing quite a lot of rents for some time. People have been benefiting from it for a considerable period, and then ultimately there was a restriction put on for a 2-year period. What is the department's current position in relation to that? Is that going to be reviewed? Because ultimately that has absolutely dived people into a very difficult situation and has led to people being removed from their homes.
So the discretionary housing payment scheme, which is available to offer or to help people who are in the private rented sector and who are subject to the local housing allowance, is delivered by the housing executive on behalf of the department. It is a cash limited budget. And that was why the housing executive felt it was necessary to introduce the changes you're referring to earlier. Well, it would have been in 2023 now. We are obviously continually engaging with the housing executive. I don't know. I mean, obviously we're in the stage now where budgets are being set, obviously for the incoming year. I don't think I could comment on whether there would be any change or reverting back to the policy. That will be ultimately a decision for the department, the housing executive, to take in discussions with the housing executive. Sorry, the housing executive will take in discussions with the department, but it will be influenced by the available budget, I would say.
Thank you.
Okay, thank you. So I just wanted to confirm, members, there are two slightly complementary proposals there. Firstly, from Ciara, that we write to the Minister for the Department for Communities in relation to this matter. Members content with that?
Yes.
Mm-hmm. And the second proposal from Kelly was that we write to the corresponding committee in Westminster in relation to the same concern.
Yeah.
Members content? Yep. Thank you. Okay, members, any objection to the rule?
No.
No. I will then put the question that the Committee for Communities has considered SR 2023/4, the Housing Benefit and Universal Credit Housing Costs Executive Determinations Modification Regulations NI 2023, and has no objection to the rule. Are members agreed?
Agreed.
Thank you, members. Agenda item 32, SR 2024/3, the Housing Benefit and Universal Credit Housing Costs Executive Determinations Amendment Regulations NI 2024 on page 531. So David and Helen, I'm conscious you've mentioned a lot of this is linked to the last one, but anything additional that you need to let us know, David, please?
It is.
Or Helen?
Yeah, I think unless the committee has any questions, obviously this SOR is the SOR now to bring in the new rates from April.
Okay, any questions, members? No. Any objections to that rule?
No.
No, thank you then. I will put the question that the Committee for Communities has considered SR 2024/3, the Housing Benefit and Universal Credit Housing Costs Executive Determinations Amendment Regulations NI 2024 and has no objection to the rule. Are members agreed?
Agreed.
So,
okay.
Chair, can you just clarify what is the increase, or is it a percentage, or is it a?
The rates, the SOR makes provision for the rates to be increased, and then the rates are calculated by the housing executive and published and that work has continued during January, and those rates are finalised now and published.
They are published?
Yes.
Okay.
By the Housing Executive.
Could we ask for that to be circulated?
Yep. Can you get that back to the committee?
Yep.
Yep.
Okay, thank you.
Thank you very much. So members, I'm going to thank David and your team for attending the committee today to assist with consideration of the SRs. I have to say I do also want to thank both the department and the clerks team for working on what was, I think, a very useful session, a much better way to get into the detail of that. And I think we've seen some really good evidence today of the committee's advisory role to the department, and I look forward to that being. But it has been operated very smoothly, and I know there's a lot of work to make it so. So thank you all for that. And now I can invite you to leave the table. Thank you. Members, we will use the same process next week again, and I thank you for your tolerance. There are a large backlog of these SRs. We are moving through them rightly, and hopefully then we'll be able to reduce the numbers down and accordingly move through them, more forensically. The next 3 agenda items, members, are SL1s. These are the proposals for new SRs which have not yet been made, and this is really the best opportunity for members to drill into the detail and to consider the proposal before the rule is made and to give any feedback. So moving to agenda item 33, SL1, the Guaranteed Minimum Pensions Increase Order, NI 2024, page 541. It is proposed that the rule will come into operation on the 6th of April 2024. The statutory rule specifies the percentage by which the guaranteed minimum pension element of an individual's occupational pension entitlement is increased with effect from the 6th of April. So do members have any comments in relation to that rule?
No.
Proposed rule, I should say. No, thank you, members. Is the committee therefore content for the department to proceed to make the rule?
Yes.
Yeah, thank you, members. Agenda item 34 is SL1, the Pension Protection Fund and Occupational Pension Schemes Levy Ceiling Order, NI 2024, page 548. It is proposed that the rule will come into operation on 31st of March 2024. The proposed rule specifies the Pension Protection Fund levy ceiling for the financial year beginning on the 1st of April 2024. Any comments, members, on the proposed rule?
No.
No, thank you. Is the committee therefore content for the department to proceed to make the rule?
Agreed.
Thank you, members. Agenda item 35, SL1, the Social Security Revaluation of Earnings Factors Order, NI 2024, page 554. Members, it is proposed that the rule will come into operation on the 6th of April 2024. The rule provides that earnings factors relating to national insurance contributions for historic tax years used in the calculation of additional state pension and guaranteed minimum pensions maintain their value in line with the increase in average earnings. Do members have any comments on this proposed rule?
No.
No. And if there are no, then I would ask then, is the committee content for the department to proceed to make that rule?
Agreed.
Thank you. Members, moving on to agenda item 36, the Forward Work Programme. So members, just a reminder that at next week's meeting, we will be briefed by the Permanent Secretary, and we will also receive a briefing from RAISE on departmental priorities. So members content to note?
Agreed.
Yes. Agreed, thank you. Agenda item 37, members, is any other business? Is there any other business members wish to raise today? Brian?
Just, I think I said before, I'll be absent next week.
Okay.
So if you could note my apologies. But I'll be back the week after.
Thank you, Brian. Any other business members? No, thank you. So members, our next meeting then will be at 10 a.m. on Thursday, 29th of February 2024 here in room 29. The meeting now, members, is adjourned. So we'll come off public session.
Committee Room 29. Sound.